Good morning, one and all present here. And today we are going to discuss about business law in the topic of performance of contract. So, what is meant by performance of contract? The term performance of contract means that both the promisor and the promisee have fulfilled their respective obligations, which the contract placed upon them. That is called as a performance of contract. For example, visit a stationery shop to buy a calculator. The shopkeeper delivers the calculator, and A pays the price. The contractor is said to have been discharged by mutually performance. So that is called as that is the example of performance of contract. According to the section 27 of the Indian Contract Act says that the parties to the contract must either perform or offer to perform their respective promises unless such performance is dispensed with or executed under the provisions of the Act or any other law. That is called as a performance of contract under the Contract Act. So, types of performance. The types of performance as an action of the performing may be actual or attempted performance. First, we will discuss the what is meant by actual performance. The actual performance means when a promisor to the contract has fulfilled his obligation in accordance with the terms of the contract. The promise is said to have been actually performed. The actual performance gives a discharge to the contract and the liability of the promiser ceases to exist. For example, A agrees to deliver 10 bags of cement at a B factory and B promises to pay the price on delivery. A delivers the cement on the due date and B makes the payment. This is the actual performance. The actual performance can be further be subdivided into substantial performance and a partial performance. Next one is attempted performance. The attempted performance are the tender of performance where the promiser has made an offer of performance to the promisee and the offer has not been accepted by the promisee. It is called the attempted performance under section 38, such as refusal to accept the offer of the performance by the promisee discharges the party from its liability and from its performance. Next one, types of tenders. The tenders, the types of tenders, it will be some important points. So we will discuss the importance points one by one. First one, tender of goods and services. The tender of goods and services, the discharge of the contract to deliver the goods and the services is completed and the goods are tendered for acceptance in accordance with the terms of the contract. If the goods and services were rendered or not accepted, the they are to be taken back by the offer or and he is discharged from his liability. It is called as a tender of goods and services. Next one, tender of money. Where the tender of money, where the debtor tenders the money which is to be paid to the creditor, but the creditor refuses to accept the money. So the debtor is not discharged from the liability to pay back the money. Therefore, a tender of money can never result in the discharge of debt. Next one, offer of performance or tender. The essential of a valid tender of performance are stated under the section 38 of the Indian Contract Act 1872. So the offer should be unconditional. The offer of performance, the offer should be an unconditional. The second one, it must be made at a proper time and a place so as to allow the party to have a reasonable time to ascertain that the person who is making the offer to him is competent to enter into a contract. Third one, if the offer to the offeree is such as delivered some goods addressed to the offeree. Then it is the duty of the offerer to provide reasonable time to the offeree in which he can ascertain that goods offered to him is the same by the offerer is bound under the terms of the contract. Next one, discharge of contract. The discharge of contract, the term discharge of contract means ending the contractual relationship between the parties. A contract is said to have been discharged when it is ceases to operate. That is the when the rights and the obligations created by the parties came to an end. A contract can be discharged if the party mutually agree to terminate the contract. Also, there are different methods through which contract can be discharged. In the in this article, we will discuss the different methods of discharge methods of contract. So, discharge method of contracts is discharged by performance, discharged by agreement or consent, discharged by impossibility of performance, discharged by lapse of time, discharged by operation of law, discharged by breach of contract. So, what is by discharge of performance? The performance means doing all those things which are required by a contract. Discharge of performance occurs when the party to the contract fulfill their obligations set out under the contract within the specified time and in the time and the manner prescribed. In such a case, the party are discharged and the contract come to an end. But if only one party perform, he is alone is discharged. Such a party gets the rights of action against the party who is guilty. The discharge of performance may be the actual performance or attempted performance. So we will discuss in the actual performance. Actual performance means when the both the party perform their performance, then the contract is said to be discharged. The performance should be complete and precise according to the terms of the agreement. The majority of the contract are discharged by performance in the prescribed manner. Next one, attempted performance. Attempted performance is only an offer to perform the obligation under the contract. When the promiser agrees to perform the contract, but the promisee refuses to accept the performance, then in such case, it is termed as the discharge of contract by attempted performance or the tender. Next one, discharge by agreement or mutual consent. Discharge by agreement or mutual consent based on the some concept. First one, novation. The novation is the term. It means the substitution of new contract by original one. The new agreement may be with the same party or with the new parties for a contract to be a valid and effective. The consent of the all the parties, including the new one, if any is necessary. Moreover, the second party must be capable of enforcement of law. The consideration for which the exchange of promise not to carry out the original contract. Second one, alteration. The alteration is refers to change one or more terms of the contract with the consent of the all the parties entered into the contract. So the all the parties must be alteration lead to performance of new contract, but the parties to be it remain the same. That is called as a alteration. Next one, remuneration. Remission. The remission means the acceptance by the promisee of lesser sum than what was mentioned in the contract or lesser the fulfillment of the promisee made. It is called as a remission. Next one, recession. The recession is refers to cancellation for cancellation of all or some of the material terms of the contract. It is called as a rescission. If the parties entered into the contract mutually agreed to do so, then in such case the respective contractual agreement of the parties gets terminated. It is called as a rescission. Next one, waiver. The waiver means abandonment of rights. The contractual rights must be abandoned due to the waiver. When the one party deliberately abandons his rights under the contract, the other party is released of his obligation else binding upon it. That is called as a waiver. Third one, discharge by impossibility of the performance. Discharge for impossibility of performance, it is called as a any of the party entered into the contract to perform their obligation. Then impossibility of performance of the contract lead to discharge of contract. If the impossibility of performing the contract is existing from the start, then it is termed as a impossibility of the performance. However, the impossibility of performing the contract may also arise the some important points. First one is an unforeseen change in the law. Second one, destruction of subject matter of the contract. And third one, non-existence or non-occurrence of a particular state of things. And fourth one, outbreak of war. Then only they have to arise the discharge by impossibility of performance. And fourth one, discharge of contract by a lapse of time. According to the Limitation Act 1963, there is a specific time period for the performance of a contract. If the promisor failed to perform his duties and the promise failed to take action within his specified period, then the promisee in such a case cannot be deprived of his remedy through the law. Here, the contract is said to be discharged due to the lapse of time. For example, John takes a loan from loan from one of his friends and agrees to pay him installment every month for the next 5 years. However, he does not pay even a single installment. His friend calls him several times, but then gets busy and take no action. After 3 years, he approaches the court to help him recover his money. However, the court rejects his complaint because he has crossed the time limit of 3 years to recover his debit. It is called as a discharge of contract by a lapse of a time. Thank you.